2022, and we are being live streamed and on YouTube and continue to meet remotely. With us this morning are Senator Benning, Senator Baruth, Senator White, and Senator Nitka, and myself, Senator Dick Sears from Bennington County, and our committee assistant, Peggy Delaney, who is the top committee assistant in the State House.
And at the State House today.
And at the State House, live from Senate Judiciary Committee. The rest of us are remote. Our first bill today is S-166, an act relating to utility construction work sites and consumer protection. Our first witness is Kyle Landis Marinello, General Counsel for the Public Utility Commission, and I probably messed up your name, Kyle, so feel free to reintroduce yourself.
Good morning, everyone. No, you got it right.
Oh.
Yeah, so I'm happy to answer any questions that anyone has on this bill. I have taken a look at it and talked with some others at the commission. And one thing I did notice, and I think you may have heard testimony on this, is that this talks about amending our rule 3.500. Which is a general rule about utility infrastructure, but we actually have a specific rule 3.700 that talks about pole attachments. And so I think that's the more logical place for a provision like this. And the other thing that occurs to me when I look at this is that we actually already have in the 3.700 rule, which talks about pole attachments, we have a provision that says that all attachments, all work done on utility poles has to be in compliance with all federal, state, local, county laws. And so another way to look at this is if there's a workplace cleanup standard, worksite cleanup standard that the legislature wants to add into this, the requirements, and I apologize for the background noise, that those provisions could just be put in statute and our rule would already then require compliance with that. And so that's another way to get the same outcome. And one benefit to doing it that way is that it would happen immediately. The way this is drafted, it talks about requiring us to adopt a rule. As the legislature knows, there's a lot of requirements around the rulemaking process. And so that would take a lot of time and resources, even for something straightforward like adding a simple sentence to a rule. And so if we were going that route, it would be nice to work with Leg Counsel on a way to write it so we don't have to go through the regular rulemaking process, perhaps some exemption for that if we're just adding in a requirement to have contracts include worksite cleanup. But I'll just reiterate that I think that we already require compliance with all laws that apply. So a simpler way may be just to say that contracts need to have these worksite cleanup requirements in them, and then that would be the law in Vermont.
Senator Baruth.
Thank you. I'm wondering, this is assuming that we don't take your last suggestion and write the requirement into statute and instead do the rulemaking. It was a little confusing to me in our last hearing, the suggestion to amend not 3.5 but 3.7. Is 3.7 more specifically directed at telecom? And I'm thinking that the committee is interested in making sure that this doesn't happen regardless of whether it's telecom wire or wire that might be used in a more basic electrical maintenance job. So your thoughts on 3.5 versus 3.7 in terms of covering the whole waterfront?
Yeah, that's a great question. And it reminds me of another thing I wanted to mention, which is the way this is phrased, it talks about the utility being liable. And I wasn't sure what the intent was of that, because utility is a very specific definition, and it generally is referring to entities that are regulated by us in terms of their rates and services. And so there are a lot of entities that attach to utility poles, or that may be attaching in the future to utility poles, that under our rule 3.700 are defined as attaching entities. And that's distinct from the pole owning entities. Of course, it can be the same. It can be the same pole owning utility that's putting its own equipment there. So if Green Mountain Power is doing electrical work at the very top of the poles, then that can be their own work on their own poles. But there are many other cable, telecom, fiber companies that are going to be attaching to poles owned by another entity. And the way this bill is currently written, the liability would only go to Green Mountain Power if it's Green Mountain Power's pole, at least as I read it. And if the intent is to apply to all the attaching entities, then it would need to be worded differently, and that would be something we would deal with in the 3.700. So 3.500, let me just pull it up, is construction and maintenance of electric, telephone, telegraph, and cable television systems. And it currently talks about compliance with the National Electrical Safety Code. That's really all that's in there, is that all this work has to comply with that. But as I said, there's a lot of work on utility poles that's below the electric space, and some of the National Electrical Safety Code is going to apply to that, but it might not be specific to the issues that can come up with those other entities attaching. And 3.700 is it's more specific in terms of it is going to attaching to utility poles. So 3.700 would not apply to work happening at an electric substation, for instance. But it's also much broader, much more comprehensive in terms of what the requirements are for attaching to poles and how that's done. And it's a relatively recent rule. We were directed by the legislature a few years ago to do a rulemaking on that to streamline the attachment process. And that rule addresses everything most everything that comes up in the attachment context. And so that's where we would naturally look for something like that. And so any entity that's attaching to utility poles, that's the rule is 3.700 that they're going to be focused on.
Mm-hmm. Thank you.
Is that clear to the members who were here? And Maria, that we might have the wrong rule that we're amending, or we might be better off amending a different rule?
Yeah, so I think that's something that you did discuss, and I just have a note that that's a policy decision for you to make. I think you heard about two specific incidents, and one had to do with attachment of fiber to existing utility poles. But then you also heard testimony about utility poles that were treated with a specific preservative that goes beyond the realm of telecommunications. So the question I think you were considering is, how broad would you like the rule or statute, depending upon which way you want to go, how broad you want it to be? I will just note that I did do a little bit of research based on your inquiry about utility pole preservatives. I spoke with the department, Jim Porter in particular. And one of the things that I, based on those conversations and some dockets that they referred me to, is that I was able to find some existing or a PUC, at that time it was the Public Service Board, but an order that approved best management practices with respect to the specific use of the preservative that was discussed last week. I think it's called pentachlorophenol, PCP. And so there are existing specific practices that do apply to all utilities with the use of that product. Now, I don't know if you still have other concerns generally about attachments, whether it's electric or telecommunications, and whether you want greater specificity. But I did want to bring that to your attention. And so at this point, I think it's really up to you to decide where you'd like to go based on the information you've heard. But yes, if you do want to narrow it to telecom, absolutely, I do agree that Rule 3.7 is probably the appropriate place for that.
Thank you.
And Chair,
Yeah, yes, Kyle.
yeah, Chair Sears, if I could respond, that's very helpful. That how that was described, and the other thing that points out for me is, and I was not aware that there was an effort to look at what was looked at in terms of preservatives on utility poles, and that could change how this is looked at. The one thing it brings to mind for me, though, is that I know A&R has been involved in looking at that issue as well. And I'll also add with something like worksite cleanup standards, that strikes me as more an issue that A&R might have the expertise in, both what's used on utility poles, what cleanup occurs there. Our realm of regulation is much more focused on the economic aspects of this utility infrastructure, who's paying for what in terms of the infrastructure and the attachments that occur. And if you look at the pole attachment rule, a lot of that is about how much does each entity have to pay for it. When you get into the environmental impacts of using certain substances on utility poles, of worksite cleanups, A&R has much more expertise in that and is much better situated to regulate aspects like that. And I think they also have more ability to address how any payments or fines might be directed if there are a violation of those requirements. We currently are limited to collecting money for violations and sending it to the general fund. We have no ability to direct any money towards harmed entities or things like that. And so I'll just put that out there also, that just because this has to do with utility infrastructure doesn't mean it has to fall on us. It sounds a lot like the Agency of Natural Resources may be a more natural entity for addressing these.
I think
types
it's
of
up
things.
to where the committee wants to go. My view is we should probably stick to the goals that were put into the bill when the drafters, the sponsors asked for it, which is really the cleanup of utility construction sites to make sure that farm animals aren't harmed by it. But I leave that to the committee, and I'm at a disadvantage not hearing the original. We have Mr. Flynn, FX Flynn, the chair of EC Fiber, is our next witness. Thank you for joining us.
Thank you, Mr. Chairman, and I appreciate the committee taking a look at this, and I thank you for the opportunity to come and speak with you today. I guess I'm here to offer some thoughts about possible unintended consequences from the perspective of someone who's been trying very hard to resolve the situation that created the felt need for this legislation in the first place. So just as a little background, the East Central Vermont Telecommunication District does business as EC Fiber, and we've built 1,700 miles of network in 23 towns. We're the state's original communication union district. We converted from an interlocal contract on January 1 of 2016 during our 8th year of existence. During 2020, we admitted 8 new towns, and at maturity, we'll have over 2,100 miles of network passing over 31,000 premises in 31 towns and parts of more than half a dozen others. Now, this has all been financed through borrowing, not through any kind of grants or anything like that. Initially, it was done with private placement promissory notes, which is a very cumbersome mechanism. And after we had 3 years of audited financials, and we went back to the investment bankers, they would say, "Why aren't you a water district? We'd sell your municipal bonds right away." So we drafted some legislation. We came to the state passed it, allowing for the creation of CUDs. And 3 months after we became Vermont's first CUD, we issued our first set of municipal bonds. We repaid most of those promissory notes. And as of last December 15th, we have $63.8 million in bonds out there. That represents well over 90% of our financing. We did get some assistance when the state built the Orange County Fiber Connector. We did get a grant for reaching some unserved locations, for putting in some conduit for trail parks out of the CARES money. But other than that, we're doing it all on borrowed money. The district doesn't have any employees. We contract with ValleyNet, which is a nonprofit internet service provider whose mission is to bring world-class broadband to areas where the marketplace has failed. Now, ValleyNet in turn contracts out most of the network construction, and principally to Eustis Cable Enterprises, which is one of the crown jewels of Vermont's business community. They're active all over the country, and they're doing work that is now the focus of a considerable amount of federal money, and they're going to do nothing but continue to grow. Now, S66 has been introduced with the expectation that it will prevent tragedies like the one that Scott and Amber Hoyt are experiencing right now. I just minutes before I came on here, I got word that another one of their cows died last night. So it's, to dairy farmers, these are like members of the family. We really can't say that often enough. Anyway, I wish I could tell you that if S166 had been in place, this would not have happened, but I can't. The contracts that EC Fiber and ValleyNet and Eustis have governing this work they have very strong language, stronger even than what 166A calls for. And as I explained in testimony before House Agriculture last week, not only does the contract specify that cleanup is required, that insurance is required, that skilled professionals are required, it also makes it plain that all of these contractual provisions are applicable to and must be passed along to any subcontractors. So, in effect, 166A was in place, at least with regard to what happened in Tunbridge. So if we look at B, which would make this an unfair act in commerce and expose those liable to punitive damages, I mean, this seems like a great hammer to put in the toolbox, but based on my experience over the last 6 months, I wonder if it would really make the insurers more responsive in a situation like this. I hope you all saw the press release we put out back on November 19th. We basically called for a resolution of this matter and expressed our disappointment that it had gotten to court, because we had been trying to use the district's moral authority to bring the parties together to get the issues resolved without having to subject everyone to the time and expense of an adversarial process managed by the courts, a lawsuit. And one of the biggest hurdles we faced was getting the subcontractor's insurer to even consider revisiting their denial of coverage, which had nothing to do with any of the claims the Hoyts were making, but had everything to do with the relationship to their customer, the subcontractor, either in terms of whether or not he, had paid on time, and therefore, when did it cancel? On what day while he was out there working did it cancel? To his lack of cooperation with them when they tried to investigate. So it had nothing to do with the merits of the case. And so I just wonder if there was the prospect of an absolutely clear path to further damages. They might have even been more recalcitrant. But anyway, we did get them to to take a look at it, and they wound up hiring a Vermont attorney to represent them in this. So nobody, they haven't walked away. Eustace's insurer hasn't walked away. Nobody's walked away. Nobody's missing. Nobody's not involved with this. And in early September, and we thought in plenty of time, we had the whole group together and ready to go to start getting this resolved. So I just worry now that, the more I was thinking about 166, the B provision, I was thinking, if that were in place, it would have just made it even more of a situation where everybody lawyers up and runs for the protection of the court. So anyway, but what?
Mr. Chair?
No.
If I could just ask a question, Mr. Flynn. I'm getting a little confused because what I hear you saying is that you were on the right track to a solution and that you fear this bill could make such solutions harder to come by. But from our testimony with the Hoyts, they are nowhere near a solution. So can you, you said in September you had everybody ready to go. We're in January now. What happened in the interim?
Well, their attorney put us off for like 2 months and then filed suit. And he had told us that he would sit down and talk to us. So we don't know what happened.
So am I understanding you right that in September, you thought you had the elements together for a financial solution and restitution to the Hoyts?
Yep, I did.
Okay. In terms of the B section in the bill, would that B section, I mean, I understand what you're saying, that it might cause people to act in a more official manner to lawyer up, as you put it, but it wouldn't preclude the sorts of solutions you were looking for in September.
No, I'm just saying that I'm just expressing a concern about a possible unintended consequence. That's all.
Well,
So,
I'll just, if I could, sort of broadly indicate a concern of mine, which is our previous witness, Mr. Landis Marinello, was talking about maybe the legislature could write something, or maybe A&R could do something, but making it clear that the PUC is not wild about doing something themselves. And then you're saying that everything was better without this bill. But, to restate the obvious, we are here because the PUC and the contractors and subcontractors could not find a solution. So
no, I'm not saying 166. I'm not saying 166 is a bad idea. And what I'm saying is that the requirements in 166A for what the contracts have to say, they were already there.
Yep.
Okay. And, my own personal observation from, again, understand the district is so far removed from the liability in this case that we have no economic authority. We have no power to make anybody do anything.
I understand that. And if I could just point to another thing, it seems like insurance and lapsing of insurance is at issue here. And I'm not clear, when you have a contractor and then you subcontract several times, I was always of the belief that someone is making sure that the subcontractors are insured, that someone has a duty, the contractor has a duty to make sure the subcontractor is insured. So I'm not clear why, if the subcontractor had a lapse in coverage, why someone further up the chain is not liable to make the Hoyts whole.
Well, I think that that's one of the reasons why the Eustace Insurance Company is deeply involved in this, for precisely that reason.
And Eustace Insurance is whose?
Travelers.
No, but I mean, who are they representing in this dispute?
I'm sorry,
Are they representing the Hoyts or the contractors or?
the contractors.
Okay. All right.
So, yeah,
So
you've got the insurer, you've got the subcontractor who did the work, you've got their
Yeah.
insurance company. You've got Eustace who hired the subcontractor, you have their insurance company.
mhm.
You have ValleyNet and EC Fiber who hired Eustace, and they both have insurance companies. So there are, 8 distinct different parties, each potentially
Yeah.
with their own attorneys. Yeah, so there's quite a number of people that are, actively engaged,
And now litigating.
unfortunately.
Yeah. Okay. I think Senator Sears has dropped off for the moment. So other questions for Mr. Flynn, or Mr. Flynn, did you have more for us?
I did just briefly have some suggestions for some things that I think the legislature and the administration might want to look at, because really the question is, how do we prevent these incidents from happening, and how do we speed restitution if they do happen? So number one, I don't think it would take that much effort to identify every easement pole in Vermont that's located on agricultural land. We have pole location data. Excellent. We have really good pole location data. And we have really good land use data. We have exceptionally good mapping. And it's pretty much a very ordinary sort of GIS analysis to match them up and come up with maps and spreadsheets of poles. And my understanding is that the pole owners inspect the poles on a regular basis, maybe not annually, but regularly. And there's no reason why a sign couldn't be developed reminding utility pole workers that this pole happens to be on agricultural land and they need to be extra careful. It's not an empty lot in Brooklyn. It's a pasture, or it's an agricultural field. And that when the inspectors went out, they could put one of those signs up on every 3rd or 5th pole or something like that. And any company going out to do work on easement poles could also bring a supply of those and put them up. So that's kind of a very practical, on the ground sort of solution that I'd like to throw out there. And I think that that's something that the utilities could take the lead on without any need for legislation. But there's another suggestion that I have, is that in terms of speeding restitution, now, imagine that the state had a captive insurance company that was designed to insure against, unusual agricultural occurrences, and that insurer could step in and pay a claim and then turn around and subrogate that claim to the insurer for the party at fault. That would put the whole process into the whole insurance subrogation process, which is a lot more technical and a lot more fact-finding and a lot less emotionally charged than a lawsuit like, what we're talking about. If something like that had happened, then last year the, Commissioner of Agriculture, could have issued a payment to the Hoyts and then turn around and handed it to the subcontractor's insurer and say, hey, we paid this claim, but it's on you. Then that insurer would process it as a subrogation claim. So that's just another idea. I don't know if that's practical or possible, but Vermont's pretty good at doing captive insurance, so I thought I'd throw it out there. But essentially at the heart of it is, take advantage of that subrogation process. And finally, I would say that I hope that everyone who's involved in thinking about what kind of legislation we might put up, I hope they're following all the filings that are going on in Hoyt versus USIS. Okay? Because they're quite interesting. I mean, I've learned a lot about how the law thinks about things like this just from looking at the initial filings going back and forth. So I hope that all of you on Judiciary and folks who are looking into what kind of adjustments might be made in 166 or some other version of the legislation, might include. So that's really, those are the points I wanted to make. And I thank you for the opportunity. I'm happy to answer any questions you have about any of this.
Thank you, Mr. Flynn. Any questions for Mr. Flynn? I guess coming at this and missing the testimony of the Hoyts and others, when something happens to somebody and there's absolutely no fault of their own, our goal usually is to get them regressed as soon as possible. These people were innocent of any wrongdoing. Their animals were harmed and killed by shoddy workmanship, in my opinion, where the field was, the waste was not picked up properly. And I think, part of this is the insurance industry, which obviously doesn't want to take the blame, would rather have somebody else take the blame. But I don't want to. I'd really like us to be able to help the future Hoyts and avoid protracted legal battles. But if it's needed, that it's there. And so I would support something that put this on to the company that did the harm. Tomorrow we're going to, or not tomorrow, tomorrow we're going to be taking up a bill that has to do with medical monitoring for harm done by companies that pollute somebody's water and their wells. And then it's that person, wants to get tested to find out if, these are cancer-causing chemicals. That person wants to get regress. And, we've seen in where I live in Bennington and North Bennington, almost, I'd say 5 years of lawsuits going back and forth, trying to reach settlement with the responsible party. Nobody wants to see that. So if the law is clearer, it helps to settle those quicker, I think. Anyway, the committee will, are there any other questions for either of the witnesses today?
I just want to ask one question.
Sure.
FX, FX, has it been discussed whether, if the insurance had lapsed, who knows? I don't know that, but does those insurances that were in place have like a tail end? I don't know exactly what that's called, whereby when the insurance coverage ends or the company goes out of business, that the insurance still is there to cover, required to be there to cover things that happened while they were insured. Do you know anything about that?
I do because, I was the CIO for an insurance company for about 5 years. When we were setting up that company, we were actually taking Pawtucket Mutual out of rehabilitation. Insurance companies can't go bankrupt. That's why they're state managed. And it's precisely because there are claims that come in years after an occurrence, years after the policy's expired, where you're still subject to having to pay out. So part of what we were doing was taking the existing assets and balancing them against the potential liabilities that we assumed could come our way. And one of the cases was a ground pollution at a dry cleaner that had happened in the 90s. And they had happened to insure it for a couple of years. And there was a settlement, and it was like, it had happened over a 25-year period. We had been the insurer of record for 2 years. So we were on the hook for 2/25 of, the settlement. So yes, that happens with insurance. In this particular case, the subcontractor was out there for 5 or 6 days, and the insurance lapsed on the second to last day that they were out there. They were covered on, 4 or 5 of the 6 or 7 days they were out there, and they weren't covered for 1 or 2 of the days. So that's one of the, facts that comes out and that you would see in the filings.
So there may be some recourse here.
Oh yeah. Oh, there's believe me, we were able to get everybody together to talk about this because there was a recognition that there was a thing here and that something needed to be done, and that I don't know, it was taking a year. Believe me, when I found out about this, the actual work had happened 18 months earlier, and the demand letter from the attorney to the insurance company had gone out 5.5 months earlier. So why were we in a situation where basically it was in stasis? And that was, the reaction of the EC Fiber board, who were all, volunteers appointed by the member towns. They were up in arms that this had just lingered for so long. And we went and we tackled this as a community organization, not as a business that lawyered up and said, we can't talk about it. I'm here today talking about it. I can assure you there are people who are not happy that I'm here talking about this.
Thank you.
Thank you. Are there any? Maria, we'll probably take this up next week. And I don't know what direction. I'm looking at Senator Baruth, Benning, and Nitka, who are here for last week's testimony, but it seems a suggestion from Mr. Landis Marinello might be a good one to look at, amending a rule rather than starting a whole administrative rules procedure. I wonder if we could do an amendment to the bill that is fairly specific to the cleanup. There's nothing to stop somebody from settling before it even gets to this point, but there needs to be some form of redress for the Hoyts and people in similar positions. So it sounds like that might be a reasonable way to go. I don't know that I don't know I want to get involved in the natural resources piece of that. At this point, certainly if the Natural Resources Committee wants to take up what they use for preservatives on the poles. It's really not what we were asked to do in this bill.
Can I just say a couple quick things?
Yep.
So one, those best management practices that what was in the Public Service Board approved related to the use of that preservative, they did involve recommendations from A&R. So there are times when A&R participates in PUC Public Service Board proceedings, and I agree that, you know, much of what was at stake there had to do with environmental legislation. So just so that you know that involvement has happened historically and probably should be, as everyone has noted, with respect to the use of certain materials, hazardous materials, potentially hazardous materials. The other thing that maybe I'll do for the committee is I'll send to Peggy links to that particular order with the report related to that particular preservative, just so you have it. I can also send you, there are examples of special funds for victim restitution. If you just want to kind of look at some examples where the state has subrogation rights. There's one with respect to securities violations. That might be something that you want to consider. I'm happy to send that. And the other thing I wanted to say is my legislative portfolio is utilities, mostly broadband and property and casualty insurance. I do a lot of captive stuff. This is the very first time where I've actually working on a bill where potentially both of those subjects have come together. So that's pretty remarkable for me. So that's all I wanted to say. But I'm happy in any direction that you'd like to go. I'm happy to work with Kyle and others.
My desire is to keep it simple and to focus on preventing cases like the Hoyts in the future. And if this legislation helps them or doesn't help them, you know, that because I don't know about retroactivity of certain legislation. I don't know whether this would be retroactive to, usually it's not. Usually you can't do something retroactive. So it would at least prevent others, and it might send a message for the insurance industry to try to make a settlement. I don't know whether, you know, it's really it's really a, you know, I think what the sponsors of the legislation were looking for is some redress for this not happening in the future. And I was surprised. I didn't realize the House was taking it up at the same time we were, and so that also was a surprise. But, maybe different versions will meet in the middle. I think this bill should also be reviewed by the Senate Finance Committee. So we'll contact. Once we make some decisions next week, I'll contact Senator Cummings. All right, great. Thank you so much, Mr. Landis Marinello and Mr. Flynn. I call it Flynn. Appreciate your testimony. And we're going to move on to Midpoint Reviews. We go from civil judgments and public service utilities to corrections.
Thank you.
I'm getting to see Commissioner Dummel on a regular daily basis, it seems, which I kind of enjoy, but you know, I don't know if he doesn't have better things to do than meet with me every day.
And now I'm asking him to meet with me.
Oh my God. Well, this is a redraft that Eric has prepared of S 183, the Midpoint Review Bill, which is basically a correction based upon two factors. One was issues having to do with the Midpoint Review Bill that we passed last year as part of Justice Reinvestment 2 that came up as a result of Judge Treadwell down in Windham County. And the second was issues that arose with corrections, feeling they were required to do a midpoint review on anyone, even those who were under new charges or serious violations. Eric, do you want to put your newest version up for the committee?
Sure, that sounds good. Thank you, Senator Sears. As Senator Sears mentioned, this is Eric Fitzpatrick with the Office of Legislative Counsel here to walk the committee through the most recent proposed committee amendment to S-183, the Act relating to midpoint probation review. This is, I believe, the second strike all amendment that that the committee is looking at. I'm just going to pull it up on my screen here. Yes, here we are. So as Senator Sears mentioned, the Act involves the process of that currently exists and which was amended again last year in Act 24 to make it mandatory in the sense that once the commissioner conducts his review of a person's record at 30 months prior to the midpoint, that if certain criteria are met, then the motion for dismissal from probation has to be filed. Those criteria are several that the committee has looked at a couple of times already, and you'll see that some of the new language involves one of the criteria that the committee was discussing at length last time, and that is that the added language that the probationer can't be subject to a pending criminal charge in order for the motion for dismissal from probation to be filed. And the clarification here, or the discussion point had been whether that criteria of being subject to a pending criminal charge should be an automatic disqualifier, or should there be some discretion provided on the part of the commissioner based on the individual facts and circumstances of each case to decide whether or not a motion to dismiss the person from probation is appropriate. So I think the direction that the committee went was that generally speaking, it is a disqualifier, as you see in the language in line 1, but it is subject to a motion if the particular facts and circumstances did warrant it. So the language clarifies that by saying, in general, it's not subject to a pending criminal charge. That means the motion shouldn't be filed. But in other words, provided that the commissioner may file a motion pursuant to subdivision 3. So it makes clear that the commissioner does still have that discretion to go under subdivision 3 and file a motion to dismiss if the circumstances warrant that. Now you see some other highlighted language here is a point that I think Senator Benning raised and was correct, that the language needed to be clarified here so that there isn't any confusion between saying on the one hand, as you do in subdivision C, is not subject to a pending criminal charge. And then at the beginning of subdivision 3 here, you see it says what it had said before was if the criteria meets if the probationer meets the criteria set forth in subdivision 1, and it didn't have the highlighted language in there. And that could have been confusing because you could have read C and 3 there at the very bottom and the very top of this page as being in conflict. And so it would have been unusual to say, well, you're meeting the criteria on the one hand, but on the other hand, you're saying, well, even if you don't meet that particular criteria, the motion can still be filed. So the idea is to make clear that if the probationer meets the criteria set forth in A, B, and D, so in other words, you don't have that conflict with C anymore. They just have to meet the ones in existing law. They haven't been found to violate the conditions in the 6 months prior, not serving a sentence for one of those listed crimes, and has completed the appropriate risk reduction services required in their probation conditions. If those criteria are met, and the person is at the same time subject to a pending criminal charge or violation of probation complaint, then the commissioner may file this motion requesting the sentencing court to dismiss. So there is some discretion there as long as those other conditions are met. So just the second change is just parallel to the one that I just mentioned. And I think that's it. The retroactivity language.
Eric,
think
can I
we
ask a
discussed.
question?
Please, sorry.
I'm really confused by the A, B, C, and D here, because C says that the commissioner may file a motion under subdivision 3, yet subdivision 3 doesn't mention C at all. And maybe I just don't know how to read this legally.
Yeah, I think because if you were saying that, because generally speaking, if you look at subdivision 3, line 12, it's saying if the probationer meets those criteria, those certain criteria, and is in other words, that they're not subject to a pending criminal charge, which is the one I'm referring to in subdivision C. If you did include that, it could be read as kind of contradictory.
Oh.
Because on the one hand, you're saying, well, if they meet the criteria set forth in subdivision 1, and if you're including C, well, the one in C at the top of the page is that you're not subject to a pending criminal charge. But you're saying, as you go on in 3 here, that even if you are, the commissioner can still file this motion.
I get it.
Yeah.
Thank you.
It is. It's. I had to actually think about it several times as I was writing it. It's confusing.
Thank
I
you.
think the basis of this, what does get confusing, is that we wanted to give the commissioner discretion, even if the probationer did have a pending criminal charge, to allow them to go through the midpoint review process. And if we didn't want to give that discretion, then we wouldn't need all this.
Yes, that's right. Exactly, Senators.
And then take care of the retroactivity. Well, that was already, that's in section 5, notwithstanding.
That's right,
else.
and that addresses that decision from Judge Treadwell that you were mentioning earlier, so that you're clear that the midpoint probation review process does apply retroactively to probationers who are already on probation when the act gets passed. And I think that
That's about
this
it.
was also, sorry, go ahead.
No, I'm just saying that that's about it for changes.
Yes, that's right. Yep.
Okay. Are there any comments from anybody in the audience who would like to make are concerned or think this is the best bill they've ever seen?
Senator Sears, this is Nick Demmel. I do have a question or a comment, if you'll permit.
Yep.
Nice to see you again today, sir.
Yes.
I have no qualms about seeing you every day. I enjoy our interactions, so feel free to keep up the cadence.
Same here. Same here.
And welcome that same opportunity for Senator White if she's interested too, and anybody else. My question, I guess, or comment is, by removing the violation of probation language from 1DC, so that's the top of 2, line 1, page 2, line 1. By removing the violation of probation there, my understanding of the way this is written then says if somebody is pending a violation of probation, then the department has no discretion. They must still file a discharge motion with the court. Whereas if they have a criminal charge, we have the discretion to say, we're not going to file a motion, or we still may file a motion if we don't think that it's necessary. And so I just wanted to get clarity on that, maybe from Eric, and make sure that that's the intent of this body, that for individuals who are pending a violation of probation, you still do not want to give the department the discretion whether to file, but say you must in fact file. You shall file a motion.
I believe our intent is to allow discretion by corrections in both, whether there's pending new charges or there's a violation of probation.
Yes, that's right, Senator Sears. If you look at line 14 of page 2, Those, if you read those lines together, lines 12 to 14, if the criteria, probationer meets the criteria above and is subject to, and this is an either or, is subject to a pending criminal charge or violation of probation complaint, commissioner may file a motion requesting the court to dismiss. So it's a discretionary, a may, not a shall. So if there's a pending violation of probation complaint, it's up to the commissioner's discretion whether or not to file the motion, which I think that's the intent.
Eric, I agree with, I think that line 14 language that starts on page 2 is correct. But I guess my concern is that above in D1, it says, if these criteria are met, then the commissioner shall file a discharge. And so if an individual has not been in violation 6 months prior, if they meet the criterion B, if they don't have a pending charge and they completed the rehabilitation of risk services, then we have to file a petition. And so there's no discretion there for, if somebody is pending a violation, we don't have the opportunity to say, oh, in this case, we choose not to file the discharge. And so I think if to create parity, we would need to capture that clause on violation of probation and put it up into 1C again.
But may I ask a question there?
Yep.
In my mind, why wouldn't we just eliminate C entirely? So that it is in the discretion in number 3, it's in the discretion of the commissioner if there's a pending violation or a pending charge. But why wouldn't we just eliminate C? I don't read.
That's certainly an option. Actually, that's a entirely rational option. That way, you would just have the language in subdivision 3, which is just saying the commission, the criteria otherwise met, the commissioner can still file the motion, the discretionary motion. So that's a possibility. If you want to cut down on that language in some sense, it was sort of I think a middle road language last time when the committee was last discussing it, but I agree that it's not necessary.
It just seems to me that it seems to be causing confusion to have it there and then have it here this way. And it might be just cleaner if we just eliminated C and pending charges and pending VOPs, it is up to the discretion of the commissioner.
Right.
I agree. I think that's more efficient.
Ditto. But if you do that, what about D?
Well,
D stays.
it just becomes C.
Yeah, I understand. But then the clarity of C is that they don't have you could accomplish this by they're not subject to a pending criminal charge. I guess you could take all of C out. You'd still have, it still gives the corrections commissioner the discretion. Okay, the majority of the committee thinks it's less cumbersome to take C out. I understood what C was doing, but
I did too, but clearly it was misunderstood by me originally and by the commissioner. So,
okay.
And I won't speak for myself, but the commissioner is a pretty
Anybody
smart
else with
person.
a
So
comment before we strike C?
I would support striking C. The less excess verbiage, the better. I think that it could be read a little bit confusing as it is, and I would suggest that sort of in the preamble to the bill that there be just a specific statement that says that the intent is to give the commissioner this discretion for violations of probation or criminal charges. One of the ways we can settle these cases when they come up, if the new crime or the violation of probation is a minor thing, is to have the commissioner do an unsatisfactory discharge or have the court do an unsatisfactory discharge to resolve the case. And because there may be no value to keeping the person on probation anymore. And I think that allows it. The less though of this kind of referring back kind of thing that's in there, the better, in my view. It can get cumbersome, that's all.
Right. Evan from the state's attorneys.
Yes, thank you. Thank you, and good morning. This is Evan Meenan from the Department of State's Attorneys. And I shared the concern that Commissioner Demmel flagged with the existing language. And I also agree with both Senator White and Matt Valerio that a cleaner approach might just be to eliminate C. And in fact, the proposal that the Department of State's Attorneys submitted to this commission in advance of this discussion takes that approach. And so there might be some language in there that this committee and legislative council could look at to implement an approach just like that. Thank you.
Okay. So, Eric?
Yeah, just the one thing I would add is that if the commissioner was saying that the clause in 1A, for example, lines 15 to 16 of page 1, if the probationer has been found by the court to have violated the conditions of probation in the 6 months prior to the review, if the point was that there continues to be no discretion in that situation, if the court has found a violation within the previous 6 months, then that's correct. I think that's what the committee intended, though, that you were distinguishing between a pending violation and one in which the court had already found a violation, so that you wanted to provide the commissioner with discretion if there was a pending pending complaint, but if the court had made the finding, then retain it as it was. Now, you could still revise that approach, but I think
No, I think that was the intent when we first introduced the bill. If the court's already found a violation of probation, then that is a signal that the person, would not be eligible for the midpoint review dismissal. It doesn't mean that they can't be some other way. We're just trying to get people off probation who've already gotten everything they can get out of being on probation. Basically. So I think it's clear to me, draft 3.1 or 2.2 would strike C and make D, C, and then stay the same throughout. Is that correct, Eric? And everybody else?
Yeah, and you could, right, and just redo that cross-reference.
Well, I'm trying to be here is to try to take a vote on it without having you have to rewrite the whole thing and scheduling it next week and get this thing out of here.
Yes, the only two changes would be the first one that you just mentioned, Senator Sears. You'd strike center to C, subdivision C, and re-letter the D as C. And then you just, on lines 12 and 13, you just change that cross-reference to just so that it would just say one. You don't need to say A, B, and D anymore.
Right. Would the committee, yes, Senator Baruch?
I would move that the committee report this draft favorably with Senator White's change and the cross-reference change added in.
Senator Baruch has moved that we'll report draft 2. Is it 2.2 or 3.1, Eric?
3.1.
Draft 3.1 favorably. Is there any further discussion? Anybody in the room or Commissioner?
Yeah, sorry to be the guy raising all the issues today. I just have one question or comment about the effective date. So the impact of this legislation will create some conflict within the department's own policies and will require us, in order to appropriately track this, to make sure that we're complying with the rule will require us to change our offender management system, which may take a little time. And so I guess my request is that we could make the effective date some date in the future to give us just a little time to be able to adjust our systems. I will propose 1 July, which I think is traditionally what we've done in the past, but certainly leave it to you to make that determination. Just wanted you to be aware of the impact that the legislation will have on the department and make sure that we can comply with the intent that's laid out here.
The reason it was effective on passage is because he's trying to correct the interpretation of both the department and the court. I would prefer 30 days or something like that, rather than July 1. I was under the impression that the House might take this up fairly quickly, recognizing that it's something that needs to be addressed. I'd hate to leave it. I don't know if 30 days is enough.
Certainly any time I think would be helpful to us, and we'll do our very best to get ourselves positioned within the time frame that you give us, but 30 days would be welcome, and I think that could be a workable solution.
Everybody okay with that?
The problem with that, sorry to interrupt, is acts take effect on passage either at a set date or when the governor signs them. I don't know. I can look into it. I don't know what you mean by 30 days from when. I've only ever heard of acts taking effect on passage, which is or at a set date. And
Okay.
you could
Let's
pick a
make it
date.
effective. Let's make it effective March 31st.
Of this year.
Yeah. And that would allow the House to change it if they get to it quickly. The House would have to change it if we do that.
Right. So if the governor, assuming the House hasn't passed it by then, it hasn't been signed.
Yeah.
The House will have to change the effective date. We'll just agree with them.
Oh, yeah, that's true.
But assume that the House takes it up in February, gets it passed by February, once it's passed both bodies and we're pretty sure the governor is going to sign it, the department can begin its work.
Sounds good. Thanks.
Or is it March 31st or April 1st? I don't know which is a better date. Because the House can always change it. We'd agree with whatever change they make.
Don't make anything April 1st.
Right. March 31st. So are there any other issues? All right, hearing none. Peggy, could you please call the roll on the draft 3.1?
Senator Benning,
Yes.
Senator Nika,
Yes.
Senator White,
Yes.
Senator Baruth,
Yes.
Senator Sears.
Yes, thank you. And by the way, Peggy's calling the roll from Senate Judiciary for the first time since March 13th, 2020.
This is true.
Which is progress. Is there a motion to report S-183 favorably as amended? I'll make the motion. Or Senator White made the motion to report. Somebody did.
Yes, I make the motion.
Okay.
I
Senator
certainly
White
did.
has moved that we report S-183 favorably as amended in draft 3.1. Any further discussion? Hearing none, Peggy, could you please call the roll?
Senator Benning,
Aye.
Senator Nika,
Yes.
Senator White,
Yes.
Senator Baruth,
Yes.
Senator Sears.
Yes. Now the question is, who would like to report this bill?
I'm fine doing it if no one wants to.
I think you would be ideal since you're the county that caused all the problems. Excuse me, you represent the county.
Okay,
You could just stand up and say, I was selected to report this bill because my county messed up the last year's bill.
Probably not the wisest thing for me to say.
Eric, I'll wait for the clean copy from you.
Thank
Yes,
you,
it's good.
Senator White. Thank you, committee. Thank
And
you
then how do
all.
I do this? Remind me again.
I'll tell you, Senator. I'll
Okay.
email you directly.
Oh, great. Okay, thank you.
All right. Great work on that bill, by the way. I will say, my recollection is Representative Edmonds wanted to take this up. Don't think she wants to wait a lot. Next, we have the aggregate value of stolen property in certain crimes. And I have Matthew Valerio first, and then Evan Meenan for testimony on that bill. And then Eric. So if you don't mind, or would you like a short break? It's almost 11:30. Can we go till noon? All right. Somebody has to step out. All right, so S 180. You're up.
No. You're not taking a break. I thought they wouldn't. Keep them going.
Senator Nick, you're still, you're not muted.
Oh, sorry.
That's okay. Matt, do you have testimony on this? Or did you want to comment on the?
I don't think my testimony is any different than the testimony I gave last week.
Oh, okay.
Because I don't think there's any, that was just during that period of time when you happened to have to leave the room. And I think I had sent you a summary of my testimony. And, you know, our position is the same, that the bottom line is, I think what we have here is a prosecution issue as opposed to a statutory issue. There seem to be crimes on the books that would satisfy this criteria. There are crimes, and that you know, I have significant concern about this 180-day period with which you could aggregate the activity of more than one person to create a felony, where in fact, if you're going to do that, you probably have possession of stolen property felony that has an aggregate amount that is the same number you're trying to get to that would cover that. But I don't think that the level of you know, whether it's a misdemeanor or a felony, or if somebody gets charged with multiple misdemeanors or the like, is really the issue. I understand that there's a brazenness that's been observed by at least one witness who came in and testified about the bill, with which people have been at least taking from the Kohl's store and maybe from other places, and that there is a concern that there is a lack of follow through by the justice system. But I don't know that this bill aids in any of those ends. I also think it's contrary to the kind of whole policy direction that we've been going at with and the legislature and many prosecutors going after regarding property crimes. Where we're on the one hand, we've got a bill in the House, and which may at some point make its way down here, involving the reclassification of offenses, and particularly property offenses and nonviolent crimes, that would, kind of bring everybody into a level of conformity with regard to property crimes. And then this one would be an outlier before we even get to the point of making things uniform. This is kind of how we have always gotten to having these outliers within the property crime area, because there's always a special interest group or a grieved victim who comes in and talks about how their situation was, wasn't dealt with appropriately by the system, and then we create another sort of crime or way to create a felony or the like out of something that was previously a misdemeanor. If you remember, retail theft was one of the long holdouts in the felony misdemeanor threshold, because it was only $100 for a retail theft misdemeanor felony threshold, while other property crimes had raised the threshold, and that was due to lobbying by the retail associations, Grocers Association and the like. Ultimately, it was changed to the $900. That $100 threshold had been there for decades, and it sounded to me from the testimony, and I actually, as I said last week, I do feel for those businesses that are suffering under this situation. But the business, I guess, is having trouble. Kohl's, for example, is having trouble hiring security, and law enforcement isn't responding in the way that Kohl's wants them to respond for the people who they do end up catching. And there is actually a remedy of where store security can detain an individual who has stolen property until law enforcement arrives. But if you don't have any security to do it and law enforcement doesn't arrive in a timely way, then you're in a problem. But it's not the law that's causing the problem. It's the what happens next that's causing the problem. And I don't see this as being much of a deterrent. It is, I think that at best you could say is, well, we did something to try to help these folks. But I don't think you're going to get anywhere with it as far as actual impact on the problem that they're seeing. That I don't really see folks, adding up their, what they're stealing to figure out whether they're at the threshold or not at the threshold. So I just, first thing I always look at is there other laws that cover it? Is what's going on constitutional? And there might be an issue here with 180-day that's kind of an arbitrary time frame to raise something from a felony to a misdemeanor, and whether or not the people who are involved even know that they are acting in concert with somebody else over a 180-day period. Somebody might have stolen something at a misdemeanor level, then kind of withdrawn from the plan, while other folks involved originally continue to do whatever they're doing. The thing about conspiracy law, which is another way we talk about to define in concert, and accessory and aiding, is that there is a current ongoing plan, and that plan can extend over a period of time, but the evidence has to be there to show that it's an ongoing situation, as opposed to somebody acting on their own individual actions, or that they have done whatever they're going to do and they've withdrawn from the plan. So this raises a lot of issues for me, and I just don't think it's going to get you where you want to get with the people who are being victimized and the businesses that are being victimized.
Senator Baruth, did you want to respond or have a comment?
I take Matt's points. I think they're fair ways of thinking about it. I would say that you mentioned the criminal classification bill, we have that, H87, in Senate Judiciary, and it includes language that is almost identical to what's in this bill. So when you say that this bill would be an outlier because of the criminal classification work, in fact, that bill includes this, and we already have it in our committee. And just a note on that, Mr. Chair, I was speaking with Representative Lalonde, and apparently they're going to be soon sending us, you remember that the criminal classification bill, we sort of thought it was cart before the horse. They are sending us 2 bills to fill in what was missing from H87. So the hope is that all 3 bills will together be something we can take up.
Well, on that matter, my interest is the drug crimes and what they do with that. That's the part of Justice Reinvestment 2 and recommendations from the Justice Center to reduce racial disparities within the criminal justice system by reclassification of certain drug crimes. So that's a priority, but I don't know about the other.
Senator Bruce, are you saying that the 180-day
I'm saying that the organized retail theft, and the last I looked at it, it was essentially the same.
Well, I would have the same issues with it in that bill then.
Yeah.
But you know, as it stands right now, this would be, you know, with compared to current law, this would be, you know, an outlier. We'll see what happens with bills that haven't been passed yet. Something will be passed, I'm sure.
Yeah, if I can ask Eric, under current law regarding retail theft, if someone takes an article worth $20 and another article worth $881, is it $900 now, or is it $20 and $890? I hope my math is right. I guess I'm trying to get to is, do you aggregate on the retail theft with the total amount stolen, or do you go by each item individually?
I think it depends on the circumstances. The potential for aggregation is there. I agree with that. I think Matt and I were in agreement on that. But you look at some of the cases, the one case in particular that I saw that was discussing aggregation, the State v. Baker case, admittedly from 1927, back when the threshold was only $25. and in fact, they talked in the case about how it had recently been increased from $7. So, you know, the thresholds increase over time, I suppose. But the case seemed to be saying that aggregation was okay for property stolen at the same time and in the same place. So I think it's that's what I mean by it depends upon the circumstances. So yes, if there was part of the, you know, same time and same place from Kohl's on, you know, the afternoon of whatever date, yes, it's 901, I think.
But if it was from, I don't know all the stores, but if it was from LL Bean and Kohl's and Macy's, I don't even know if they're still in business in Burlington, but it was from those 3 stores and it aggregated to 901, would it be a felony?
That's less clear. Probably not.
So I think we're looking at 2 changes, trying to accomplish 2 changes. One is to have the aggregate clear, and the other is if it's in concert with other people. And I wonder about the 180 days, and I take that. But I also wonder if this is just, you know, prosecutor in A county does it one way, prosecutor in B county does it another way, and prosecutor in Essex or Orleans does it another way. Senator White.
I have to say that this is one of those bills that I feel very uncomfortable with. I have some issues. with the 180 days, I have an issue with that because I'm not sure why 180 days as opposed to 90 days or 240. 6 months, I mean, that's essentially what it is. I'm also know that there's other laws that could address this, and I don't know that I haven't read what's the aggregate in the whatever that other bill, the sentencing, the code that we're looking at. I also think that part of this, as we heard, was an issue of workforce. And I feel very uncomfortable passing a bill because if those stores had adequate, what they call security, then perhaps they could detain people and the cops would come, or they could just prevent it because people are less willing to take the chance of stealing if they see somebody standing there in a uniform. I also think that the adding up to the 900 is pretty iffy because the prices at different stores are so different. How would you account for somebody steals something, a toaster from Walmart and it's $22, but they steal it from Kohl's and it's $46? I mean, I don't know how you put a value on that. I'm just really uncomfortable with this bill. And I think we have other ways of dealing with this issue. So I have not yet been convinced to support this. Just letting you know.
Thank you. My question, I guess, for Evan Meenan or anybody else is this a problem of prosecutorial discretion?
I can try and answer that if I wasn't sure if that was okay.
Yeah, I think that's the question that Mr. Valerio believes that the laws already exist to deal with this. It's just that the prosecutor in some counties choose not to deal with it, in other counties they do, which is
well, and law enforcement too, and the stores and their ability to hire.
Yeah,
you know, and it's even how it's charged. I mean, and I'm sorry, Evan, but some counties will. I mean, one of the typical ways of resolving some of these things is say, look, I won't charge you with the felony, but we'll put you on probation for 3 misdemeanors. Even though they add up to $900. And that's for something that occurred where the theft was all at the same time from the same place. So,
I guess that, do we need a law?
I might be able to provide a little bit more information that could help inform that decision point. And for the record, it's Evan Meenan from the Department of State's Attorneys. The additional information has to do with 2 topics that I attempted to sort out prior to my testimony today. The first was there was a question, I guess, at some point about whether or not state's attorneys had some sort of minimum threshold for the value of property before they would move forward with a charge. And then the second question was, what's the present ability to aggregate value under existing law, which I know both Matt and Eric have testified a little bit about this morning. So I attempted to reach out to all of the state's attorneys to figure out whether or not they had any kind of policy in place that said the value of the property needs to be X amount before we're willing to move forward with the charge. I didn't hear back from all of the state's attorneys, but I think I heard back from a vast majority of them. And the universal answer to that was no, we have no hard and fast policy to that effect. However, there was some uniformity in their general approach to these types of cases, whether it's a larceny or a retail theft. As a general matter, as with any other case, when they're deciding whether to charge a case and how to resolve it, they review the case based on the individual case at hand and the presence of any aggravating and mitigating circumstances. However, when it comes to those 2 types of offenses, then, consistent with the diversion presumption in 3 VSA section 164, quite a few of these cases get sent to diversion. And that law, section 164, basically says for any offense that's a qualifying crime, and those would be the ones eligible for expungement, the defendant has to have an opportunity to participate in diversion unless the prosecutor states on the record why diversion would not serve the ends of justice. And so looking at the individual aggravating and mitigating circumstances, quite a few of these cases get sent to diversion. And that's especially true if it's not a grand larceny, because grand larceny is not subject to the presumption. If the property has been recovered, or if the losses are insured, which is just a long way of saying no restitution would be owed to the victim. Unless there really is some type of aggravating circumstance, like a really lengthy criminal history, another crime that was committed at the same time, or maybe some type of act of violence was committed while one of these offenses was being committed as well. So, the state's attorneys view this diversion approach as being consistent with some of the criminal justice initiatives that have been passed the past couple of years. And that's the approach that they've been taking to many of these offenses. With respect to the present ability to aggregate the value of stolen property, I think that Matt and Eric are essentially correct, and that it's pretty clear under existing law that if the property is stolen at the same time from the same victim, then yes, you have the ability to aggregate the value of all of the property to see if you're going to get to a felony level offense. If that's not true, however, and the property is stolen over a period of time or from multiple different victims, I think it's a little less clear under Vermont law whether or not we can aggregate the value. I think that Matt is probably correct that possession of stolen property would be the most likely offense that we could charge where we could do that, because you'd be looking at the moment in time you'd be looking at would not be each theft, but what's in the person's possession at the time they were detected. So, however, I would say even if we were to pass this law and we would make it easier to charge a felony level offense without having to confront that presumptive diversion statute, my guess is cases would continue to be reviewed on their individual merits, and there'd be quite a few folks who would still get a diversion referral, especially if it was a crime that was committed at least partly as a result of being economically disadvantaged, or having a mental health issue or a substance abuse issue that does not necessarily warrant a more traditional criminal justice response.
Thank you. That makes it clearer, I guess. So there's a question. I guess the bill would only be needed if there is actual coordination and more of a conspiracy. Is that what I'm understanding?
Well, I think there's two different layers to that question. I mean, we have accessory theories of liability like conspiracy, accessory theories, aiding and abetting theories, in order to sort of try and address the organized retail theft problem that we're seeing. So that's one question, one layer of the question. And we do have tools that we can use to address people acting in concert with one another to commit an offense. The other question, though, is the idea of adding up the values of property over a period of time. And the sort of conspiracy theories of liability and accessory theories of liability don't really get at that question directly, although they might help a little bit.
So would we either drop this bill or we look at, as I understand it, possession of stolen property.
I think that that's correct. When I reached out to the state's attorneys to figure out what their charging practices were, nobody's response said, this bill is going to help us address organized retail theft in our communities. Their responses were more general and said, this is how we review retail theft and larceny cases. And because of the existing laws related to diversion, quite a few of these cases get diverted from the traditional criminal justice system. And I anticipate that would still be true for many, many offenses, even if this law was passed.
Okay. Committee, you want to take a look at possession of stolen property and how that all works?
Sure.
Yeah.
That might entice Coles into taking their stuff back that was stolen before it gets stolen, I was interested. Eric sent us a copy of the law that allows somebody to detain somebody who's stolen property. Does the person have to have gone through checkout before they can be detained or fail to go through checkout? When I went to Walmart the other day, I admit it, it's a place where I had to go get something that I can't get anywhere else. And I was walking out of Walmart, and after I checked out on the self-checkout, there was a guy standing there looking at me, and he had a Patriots hat on. And I said, hey, let's go on tomorrow night, but unfortunately it didn't work. But, he was there to make sure that I wasn't stealing something, I assume. So at that point, could they detain me?
I would think so. I mean, I think
Because
that
I've gone through the checkout and I didn't pay. I did pay, but if I hadn't paid, he could then detain me because I've got property I haven't paid for.
yeah, I think for the privilege is to detain you for a reasonable amount of time to do a reason. If they've got some suspicion that you might have stolen something, they can check your bag.
Actually, that's a part of the problem with the new plastic ban on bags, by the way. A lot of people put their stuff in their bag to carry around, before they go to check out. And sometimes people forget to take everything out of the bag or they find out there was some little item buried in the bag they didn't take out. Anyway.
So could I just ask a question? So are you asking, could just a regular clerk who's posted after the checkout, could they detain you, or does it have to be an official security person?
No, that's what I was asking. Yeah. Can the guy standing there with the Patriots hat on?
Right. Can he detain?
And I had my Patriots mask and my Patriots hat on, and I was all geared up for the game. Can he say, wait a minute, can I see your checkout slip? And if I don't have one, you'd say, well, wait here a minute. Call the police.
Yes, they can. It doesn't have to be a security guard. It can be someone who works at the store.
I don't even have to try to leave the store with it. I've seen it charged as attempted retail theft before, where you've got people who shove the stuff up under their jackets or under their shirt or whatever, and then before they even leave the store, they get caught. And usually what ends up happening is they get the property back and the store issues a no trespass order and says get out of here, as opposed to charging them. But I have seen it charged as attempted retail theft just for secreting the whatever you're trying to steal up under your clothes or in a bag or backpack or whatever.
Let's hold on to this bill, Peggy, and schedule some time to discuss possession of stolen property Now that we've made clear people can be detained when they
And can
leave the store.
can I just ask another question?
Sure.
How hard is it to get a no trespass order?
You have to do is ask. You just have to, it's just a form that you fill out and you give a copy to the person you want gone, and you keep a copy for yourself, and you send one to the police.
And what's the charge with a violation of a no trespass order?
Unlawful trespass. It's a misdemeanor, unless, there's unlawful trespass felony that's into a dwelling, and then there's repeated. If you do it repeatedly, you can get a felony, but it's a misdemeanor.
I mean, it seems like maybe some of the stores, if they have all these people on camera, which some of them said they do, why not get no trespass orders against these people that are continual violators? Or does it just go no place?
Well, I mean, again, it's one of those in the general scheme of the crimes that we deal with. It's pretty low end stuff.
Yeah.
And I understand that it's very frustrating, but it's all relative, I guess.
Also might be helpful if the retail associations in the various counties work with the state's attorney to find out what their rights are and what they can do and can't do.
Mm-hmm.
And just to the unlawful trespass question, if I can, and this is Evan Meenan again from the Department of State's Attorneys. My recollection is that unlawful trespass, at least at the misdemeanor level, would also be subject to the presumptive diversion referral. So again, the criminal justice response might be very similar. We would be looking to see, is this a crime committed as a result of poverty, substance abuse, mental health issues? Is this something that, consistent with previous legislative initiatives, should be diverted from the criminal justice system? So the analysis might be fairly similar to the underlying theft itself. And then the other thing to consider is, shopping opportunities in rural environments in Vermont. In Chittenden County, if you're banned from going to the Walmart, that might have a different effect than if you're banned from going to the Walmart in a more rural community. So, in an ideal world, we simply would have less shoplifting, but the world is not yet ideal.
I'm just suggesting that maybe the various chambers of commerce or other groups who deal with the retail industry might want to have discussions about what their rights are with their local state's attorney. It might not hurt to talk about this problem, and whether they get support or not get support is a question. But I'm willing to continue to have a discussion. I think it is a problem, and I do think that what we're seeing in other states, where it's well organized and well choreographed, is something that might be able to get at it. At the very least, we're educating ourselves and hopefully educating the general public about the problem and what are some of the current law solutions. So I thank you all for hanging out here. We have the governor's budget address at 1 o'clock, so we're going to break a little early. And I know most of us have got to get to the State House and get to the Joint Assembly. Oh, wait a minute. No, we don't have to. We can use the extra 5 minutes anyway. Thank you. And Peggy, it's good to see you. Maybe you could come online so we can all see Senate Judiciary again.
Sure. Hold on.
Maybe we'd like to take a view of the Senate Judiciary Committee room.
There you go.
Wow.
Oh, yeah, I bet.
Wow. Look at that.
Where's the new?
Wow.
Where's the new TV?
Where is it?
Let me see if I can go up there. Hold on. Can you
Somebody
see it
stole
now?
Oh, there it
Oh,
is.
yeah.
Oh, it's
Yeah.
where your great uncle's picture was, Dick.
Yes.
Yeah. No, actually, it was Calvin Coolidge that my great uncle had taken. I
Oh.
hope they put that somewhere else.
Is it in our room still, Peggy?
They didn't close off Alice's vault.